Hi, everybody. This is Anthony Paradiso with Industrial UI, and then JoLynn Haresign with me as well. Want to say hello, JoLynn?
Good morning, everyone.
Good morning. Hi, everybody. We are excited for today's webcast. We're really, we thank you all for joining us today, joining us with this for the webcast. Today's topic will be the latest Supreme Court rulings, which there's been a lot of questions about that, but just a little bit so you know what Industrial UI is, who we are, what we do. We have been handling unemployment insurance claims for employers, not just claims, but the whole process through the unemployment insurance process. We've been doing that since the late 60s, and we just recently opened up an HR support division, which myself and JoLynn are running. We do everything, anything really surrounding employee relation consultation, harassment training, compliance training, leadership training, handbook development. Am I missing anything, JoLynn?
No, I think you got it all covered.
We're your as JoLynn would say, we're your HR friends. So just think of us that way. Any questions, reach out to us. My email address is APARADISO, so Paradiso at industrialui.com. And JoLynn, how can people reach you?
J Haresign, Haresign at industrialui.com.
Perfect. Thank you so much. You could follow Industrial UI on LinkedIn. You could also find JoLynn and myself. We're on social media, Instagram, LinkedIn, all those different social media platforms we're on. So you can definitely find us somehow. So getting right into the latest Supreme Court rulings, and just a little bit of a side, I have two dogs home. So if you hear some barking, there's been some action going on outside my house. So if you hear anything, it's just them. Also, my husband is home. He's a teacher. So it's summertime, so you might hear there's a lot of action going on today at the Paradiso household. Anyway, so I just wanted to mention that. So Supreme Court ruling. So I'm going to go right into the first question, and don't mind me if I'm turning my head. I'm just looking at my notes that I have for today's webcast. So the first question is, how will the recent Supreme Court rulings impact HR overall? How would you answer that, JoLynn? I mean, it's a pretty long-winded answer, I'm sure. There's so much there.
Yeah, I'm sure that in the near term, the impact. I mean, I know a lot of these cases were remanded back to the lower courts, and again, I'm not an attorney, nor do I play one on TV. So this is from an HR perspective, of course. But from what I've attended a few webinars on these topics, and I understand that a couple of them have been remanded back to lower courts to get further clarification. However, I would be examining policies with respect to reasonable accommodation for religious accommodation, especially in light of the U.S. Postal Service case, Groff versus DeJoy. And then, I'm assuming that in reading the decisions with regard to, diversity in the affirmative action cases in the universities, um, my opinion is that although it seems like this could have far-reaching HR implications, it's not there yet. And there's no reason for anyone to abandon any sort of diversity, equity, inclusion programs they have going on because, aside from anything else, having a diverse workforce is a benefit to anyone, regardless of, how we couch it. We have to have a workforce that accurately represents your population, accurately represents the kind of culture that you want in the workplace. So, although I would say we should be closely examining our policies and programs just to see, kind of recalibrate where you want to be and what is it you're trying to accomplish, I wouldn't get too completely disheartened about some of the, decisions that have come out. What are your thoughts, Anthony?
No, I agree. I mean, I think nothing really is written in stone yet. Really, there's these decisions. We don't really know how they're going to impact the workforce, like you mentioned, really, and also we're not attorneys, both JoLynn and I. and we certainly don't play ones on television like JoLynn said. So please, again, this is more of an HR business perspective of where we think employers should do. And I do agree that definitely look at your policies, your handbooks, the religious accommodation. I mean, and I'm going to read the a little section of the Groff versus DeJoy decision, because our next question really dives into it a little more. So I'll read that, a little part of that in a second. But there might be future decisions to come down the road. I mean, I think, if I'm not mistaken, the term ended for the Supreme Court, so there really shouldn't be any more. There shouldn't be more any recent decisions coming out, but or upcoming decisions. But yeah, I mean, we have to. Listen, there are concerns. I know there's political implications, and that's a future questions that we'll be answering as well. But yeah, I think monitoring your policies, joining webinars, talking to attorneys, getting as much information as you possibly can. Don't assume things. If there's a question that comes from an employee, don't automatically just say yes or no if you don't have the answer. Look into it a little bit. There's nothing wrong with saying to the employee, let me look into this a little more, let me get back to you. There's, we all don't have the answers, and attorneys too. So just kind of just be patient. But I agree with the policy perspective. Definitely looking at your policies. I'm hiring outside consultants to look at it, attorneys reviewing it. Just making sure that everything is legit and right. But really, there's been no direct implications as of yet, but there could be to come. So the next question has to do with the fair admission. The following question is more specific for the Groff versus DeJoy, but the next question is regarding the fair admission decision. And the question that we have is, will the student for fair admission ruling have an impact towards DEI employment? But let me just read quickly the part of that decision. I'm not reading the whole thing, so this is a little bit of a snippet from the decision. So again, this was students for fair admission versus Harvard and students for fair admission versus University of North Carolina. There were two cases combined. And this is the Supreme Court found that Harvard and the University of North Carolina's admissions policy violated the Equal Protection Clause of the 14th Amendment. Both cases overlap because UNC, which is University of North Carolina, was a state school, and the question was whether its affirmative action program violates the 14th Amendment's guarantee to equal protection of the law. And even though Harvard is a private institution, it still is covered by federal anti-discrimination laws because it accepts federal money for a wide variety of programs. So that's part of the decision. Again, for the students for fair admission versus Harvard, and students for fair admission versus University of North Carolina. Again, I know we're mentioning a lot of different things here. There are a lot of, last month there were a number of rulings that came out just one day, back to back. So again, I know we're mentioning a lot of different things, but we want to make sure we get all of those rulings, get them all discussed today. So now the question again, is, will the student for fair admission ruling have an impact towards DEI employment? And what are your thoughts on that, JoLynn?
Yeah, I mean, there's a lot of information to kind of pick apart and look at. I know that as far as the decision goes, right now it only applies to, universities, colleges, people who accept federal funding, are covered by federal anti-discrimination laws. But, you can certainly see where, this type of decision can have wide-ranging interpretations for private industry. So I will always say to proceed with caution, talk to your labor and employment attorney friends to get a better idea of the landscape that we're going to be looking at in light of these decisions. What's the future implications for private employers with respect to, looking at race, or looking at, again, diversity and inclusion and equity programs that you're thinking about initiating.
Yeah, no, I mean, and obviously there's been certain states that have been, there have been a lot of issues with DEI in certain states. And I'm not that I want to go into specific states, but yeah, I mean, there's certainly, I mean, like you said, right now the impact is towards universities, education institutions, and from what I'm reading, I don't really, I'm finding, and again, I mean, from listening again to what I'm reading, I, it seems that a lot of the institutions, education institutions, are still going to follow their same standards that they had been doing, prior to this ruling. So I mean, hopefully universities will kind of will still uphold what they have been doing in the past. So this may actually, again, some rulings sometimes have a backfire, and it could backfire positively, for DEI initiatives. So I'm trying to be optimistic with this, but you're correct too, Jill. I mean, we can see where the landscape is going. We can see where this is leading towards. So again, proceed with caution. Speak to your labor employment attorneys, your general counsel, outside consultants. You can always question JoLynn and I. We can certainly try to get information for you as well if you want to start initiatives out there. Certainly reach out, but again, but right now it's really right now with educational institutions, and that's it. But again, proceed with caution. The next question dives directly with the Groff versus DeJoy, which is more of this has more direct implication right now for businesses more than likely. And I'm going to read a little bit on that. The question that we're going to answer is, how will Groff versus DeJoy have an impact on organizations? But before I get into that, let me just kind of read this quickly, what the Groff versus DeJoy, which was a Postmaster General. Let me just read this to you quickly. Title VII of the Civil Rights Act of 1964 requires an employer that denies a religious accommodation to show that burden of granting an accommodation would result in substantial increased cost in relation to the conduct of its particular business. Title VII of the Civil Rights Act requires employers to accommodate the religious practice of their employees unless doing so would impact an undue hardship on the conduct of the employer's business. So to the question again, JoLynn, how do you feel that the Groff versus DeJoy decision will have an impact on organizations?
Well, so in my reading of this, and again, I took a few con law classes in college, so I'm relying on my constitutional law nerdiness to get me through these Supreme Court decisions, which fascinate me, by the way. So from what I read in the decision, it really upends the definition of undue hardship. So it really clarifies what that means. I think a lot of us have, come across this situation where an employee, says, I have religious observance on a certain day. I can't work on that day from a specific period of time. And then the employer comes back and says, well, I can't really grant this accommodation because of the needs of our business. It would cause an undue financial hardship or an undue hardship because of the increased overtime costs, of the increased, employee morale would, be affected. So I think the Supreme Court decision now is really forcing us to examine those practices in particular. And it's no surprise, given that the First Amendment is freedom of speech and exercise of religion, no established religion, to give employers this pause for a minute and say, this is the First Amendment, this is very important to the Constitution, and therefore employers and government agencies, etc., really need to make sure that we are protecting an employee's sincerely held religious beliefs. And so we're going to make you do a more comprehensive analysis of that undue hardship. So this decision in particular is kind of redefining what that means with respect to religious accommodations. And it could have other impacts for other types of accommodation. But for the most part, we really need to be focusing on redefining for ourselves, examining our policies, and practices across the board to make sure we are consistent as far as religious accommodations. How can we show an undue hardship? What does that mean? We really need to dig deep and really do a comprehensive analysis of what that's going to mean for us and for the employee.
Yeah, I very well said. I completely agree. I mean, I think this definitely does, it does slow the process for employers now, in the sense of that, they have to really kind of now think about when someone makes a request, what is it, what should we do here? Not automatically just saying, no, your request is denied. I think now, not that I think, but most of it now, it the way it appears is that employers should try to be accommodating to their employees when they make these requests. So I mean, I'm not going to just say yes all the time. Obviously, you have to examine it all. But I think employers need to examine it carefully when an employee makes a request for a day off because of religious observance. Carefully review it, carefully understand what the religious observation is. A lot of times when a person asks for religious observance day, a lot of times I don't think we even know what the observance even is. We just kind of say no without really understanding what it is. So it's that education piece too, which is another question we have coming up in a few minutes. Is kind of educating yourself on these different, because there's various religious holidays that are out there that we don't know about. So just kind of making sure that our management supervisors know what's out there, what's coming up, what to expect. And again, listen to your employees, pay attention to the requests. Again, you don't have to say yes or no right there and then. You can give it a day before you respond. Get the facts and information straight before giving any kind of answer, because that answer you give can be a decision can be an answer that you make that could that could have a very big impact in the future for a court case or for anything else. And then, like you mentioned too, be consistent. If you grant one person a religious accommodation, don't if someone else makes a similar request, you have to be careful with how you grant that decision, or not to deny it. You have to be consistent with your decision. So I think that's very important, and looking at your policies. The next and we kind of been this is kind of we've been answering this kind of throughout the previous questions. How should HR and organizations plan for the future? Where do we go from here? I think we basically have kind of answered that, reviewing your handbooks, reviewing your policies, speaking to your labor attorney, your counsel, your consultants, speak to them, get information, making sure that your policies are updated. I know a lot of employers still haven't updated policies before COVID, and COVID alone has made a lot of changes to policies with remote work, hybrid work. Now you have these recent Supreme Court rulings. So just making sure that your handbook is updated, because your handbook is updated. Remember that your handbook is your kind of like your, is one of the first things employees see when they're hired. So making sure that everything is clear, consistent, concise, not confusing. I think that's what it comes down to. Educating yourself. We're being very repetitive here with some of the things, but they are very. It's very, you do need to make sure that you're aware of what's going on. Educating your employees. How about you, JoLynn? What do you think? What other things could HR and organizations do to plan for the future?
Oh, educate your frontline managers, supervisors, department heads, get their buy-in, let them know that, we can't just dismiss a time off request or a request for accommodation out of hand due to, de minimis burden on operations of the business. It's going to require a lot more thought and detail. So those requests should go through, human resources, employee relations, someone who has the time to examine and the knowledge that they would need to examine those requests. And, definitely education is going to be a big one.
Yeah, we're learning that for sure. Education is a huge component, and I see that employers are starting to now, it's a buy-in for education, either it be it could be in-person education, it could be online education. There's online education. The employee can take the of course as they throughout the day as they can throughout with their time. So yeah, definitely education is a huge component. If your staff and workforce are educated with the different various things that are going on, they're going to handle them correctly. And I think you're right too. You mentioned training your front line, getting buy-in from management. It could be anywhere from evaluation performances. How do you go about doing that? How do you document workplace investigations or your disciplinary actions? We may think that some of those things are common sense things to do, but if you're not doing it every day, then it could be, some managers maybe don't know certain language that should be in there. And you mentioned too, having HR in mind as well. Not that necessarily HR has to be in the meeting directly with it, but they can at least maybe review documentation that's going to be provided in a personnel file or whatnot. So definitely, I definitely think frontline management, your supervisors need to be trained and conversed with all of these different laws that are happening. It's a lot of stuff. Listen, it's not easy. This is a lot of information. From speaking for myself, this is something I do every day, and it's a lot of information that I'm dealing with. So I can imagine management that isn't dealing with these everyday things, how it could be for them. It's a lot of information, can be very confusing. But I think also transparency is also a very important thing. Making sure you're being transparent with your management, having open lines of communication, so they feel they could ask HR questions and not be nervous about doing it. Because I know sometimes people get a little nervous with asking questions and making sure that people are comfortable doing so. So there's a lot there. This is the last question before we end. So the latest decisions have a serious impact on many people personally. Due to the recent rulings and political tension, how do organizations deal with employee differences? JoLynn, you want to start this one off?
Yeah, again, I always say proceed with caution, but also, make sure that your, compassion in your heart is in it too. I mean, keep in mind, as an HR professional, we're always focused on compliance and the rules and all of that stuff, which is wonderful. We should be, because we are the protector of our organization, but also we are the protector of our employees. And right now, there are a lot of things going on in the world that can be frightening for a lot of our fellow employees and people that we work with very closely. And just have your, wear your compassion on your sleeve and make sure that we are, moving forward with compassion and understanding that there's a lot going on, and we need to be mindful of that and how those things are impacting the way we work and the way we work together. But always be listening, always be available to employees so that they can express their concerns, and I think that will make the difference.
Yeah, I agree, and I posted something recently on LinkedIn about my own personal thoughts, and regardless of what my personal thoughts, my political my political affiliation, regardless, we're all people, we are all humans. That's where obviously with human resources for a reason. So we are dealing with humans, and people's emotions and everyday lives. So definitely being compassionate, empathy is a huge it's a huge characteristic that we now want to see in our leadership, which was really more post-COVID, but we are seeing a lot of employees wanting their leaders to have empathy towards their employees and issues that are going on. So with that, we are going to have political differences, and we're nearing a presidential election in 2 years, so that's going to be a whole other and it's going to probably be a very tense election, which then brings issues to organizations and the workforce. And I think we just have to realize we have those differences, respect those differences, And I think connecting the DEI part of it, diversity, equity, inclusion, is, making sure we have that diverse workforce, making sure that we're listening to one another. And again, it's the education piece. Employers, it's almost like an obligation now to educate your employees on these various issues. Because the more education that people have, the more the more things they're going to learn about each other. The differences that we have, respecting those differences. So I think, just educating each other is really important, and just having that compassion and just really listening to one another. I think we're getting there. Employers, I really see there is a buy-in now from management on these various trainings to have, and the trainings can vary all the way from regular everyday leadership training, with learning again about just having that compassion, just how do you motivational kind of things, how do you motivate your employees, and then all the way to DEI training. There's so many different trainings that you could have out there. There is not like a one only training, and again, it takes time too. It doesn't just take it takes a while to educate your employees, but definitely worth the investment. So yeah, we're almost out of time. And I know we had a lot of stuff to go through today with the Supreme Court rulings, but we thank everyone for joining us. Again, earlier we mentioned our email address. I'll mention it one more time in case you missed it. But just feel free to reach out to JoLynn and myself. We're here to help. We're your HR friend. So just feel free, any questions, comments, any future topics you want us to discuss, let us know. Again, my name's Anthony. My email address is aparadiso@industrialui.com, and we'll be around in the future for upcoming webcasts. And JoLynn, how could people reach you again?
J Haresign, HARESIGN @industrialui.com.
Perfect. Thank you. And again, you can go to our website, industrialui.com. You can see our website, our LinkedIn, all information's there. Again, any questions, always feel free to reach out. Thank you so much. Bye, everybody.
Thank you. Bye-bye.